I think the first question, at least that comes to my mind in these days, while thinking about the Constitution and evaluating the Constitution 75 years down the line, is regarding the provenance of the Constitution. So we have seen a lot of pieces and a lot of viewpoints. One example I think that comes to mind is Argho Sengupta's book, The Colonial Constitution, uh, which I think essentially argued that the constitution that we have is essentially a legacy of our colonial, of our twisted colonialism, or the fact that we were ruled for so long, for 200 years or so, by under British colonialism. A lot of people use this fact that there are a lot of continuities in the constitution from the preceding period of colonial rule to malign or critique the constitution. How do you look at the origins of the constitution and the provenance of the constitution against such charges? And do you think that the origin of the constitution in any ways uh, was a blemish, even at the time when our national leaders were sort of grappling with how to craft something new for a nation which acquired independence? How do you deal with these accusations?
Yeah, well, there's a common misunderstanding that the Constitution is colonial. In fact, it's a break from coloniality. We were subjects of British Empire, of British monarch, till 1947. From subject, we became citizens, free citizens of a republic, not of a monarchy. So to say the Constitution is colonial is either a thoughtless statement or it is a political statement. I won't elaborate on the distinction between the two. But for us, anyone who looks at the Constitution, it's a revolutionary document. Constitution makers sat for 2 years in Constitutional Assembly when India became free and drafted a most remarkable document. Now I know there is this view that everything is colonial. What is not colonial? We're talking in English. Right? So we're talking on a digital media, which I suppose invented in the West. I don't go there, but people go to social media, Facebook and chat, whatever, all the Instagram. I don't go there. I'm a deglobalizer. So I've stopped at WhatsApp. I'm not proceeded to social media, Twitter, anything like that. I don't know what goes on there. Accepting hearsay, what other people say about social media, it's my duty to listen because they're saying it. And when they bring it to my attention, I look at it. Otherwise, I have nothing to do with it. So everything is colonial. If you look at the Indian Constitution, one of the bogies of the century is that Indian Constitution is Government of India Act 1935 writ large. And who gave us the Government of India Act 1935? The British. They tried earlier in 1919 to give us Chelmsford Montague reforms for home rule. Now, nothing can be further than truth. If you look at the Constitution, its structure, first of all, ours is a post-liberal constitution, not a liberal constitution. Ambedkar was very careful not to copy the old precedents in constitution making. He was extremely careful, and so was the drafting committee. So look at part 3, which contains fundamental rights. And Baba Sahib introduced a unique It's a unique document. He introduced Article 17 and put into quotation marks, untouchability into quotation marks, is hereby abolished. It's 3 sentences. Its practice is forbidden. And any such practice will become a constitutional offense. Now, which constitution in the world declares an offense the function of criminal law, not of constitution? Not merely Article 17, but Article 23 and 24. Article 23 prohibits begar and agrestic serfdom. And Article 24 says the state shall provide compulsory and free education up to the age from 6 to 14. That's not directive principle. That's in 24. And not to do it is an offense. And Article 35 of the Constitution, it's a part of fundamental rights, says that notwithstanding anything in the Constitution, that's all the details of federalism, the principle of federalism, Parliament has a duty to pass legislation expeditiously on the conduct described as offenses in the Constitution. Now, that is not a copy and paste job. That's originality at the highest point. To find me a statement like this in 35 1999 reform, 35, no, you won't find it. So if we wear blinkers, we can say anything black. India is a free country. We can say Constitution is colonial and all that kind of utter nonsense, if you like a mild word. It is wrong. And the great jurist and a judge of Calcutta High Court, a great jurist of India, Durga Das Basu. Durga Das Basu wrote a book called A Shorter Constitution of India. Very difficult to make constitution short, but he did it. And he says the Constitution of India is not, in 1955 he said it, that Constitution of India, I quote, is not Government of India Act 1935, it's a capital font. It's very original. Early 1955. Now, I don't know what you read, but none of the later generations have quoted him and contradicted him, and taken the normative labor of saying he's wrong. They've just ignored him. It's strange kind of scholarship. The fundamental rights, the big break with the past. The idea of a republic, and I came to India very late, 74, before most of you were born, but that's a different matter. I'm sorry for that. I apologize. But there was a man called Daftari, Chandubai Daftari. We used to call him Chandubai. And Chandubai said, republic is an idea which is never discussed in the Constitution by constitutionalists. But it gets into fun, mischief. So Chandubai said, I like the word republic because the word republic has a pub in it. Right? Pub is what? The site of fraternity, site of conviviality. People gather together to discuss many things. The idea of republic is the idea of citizens, congregation. I've said very often myself, what's the Constitution? And I've said a constitution is a congregation of citizens, free citizens with rights. If you take away citizenship, if you take away freedom, you are acting, or try to take away, you're acting unconstitutionally. Although that's often said, and I agree with that. So before I go further, let me stop, and because the conversation, I should not have one-sided dictation. So tell me, you're with me on this, or you have a different idea?
I do agree. In fact, while studying about the civil rights movement in the United States, it did occur to me that the Voting Rights Act, I think, wasn't passed until 1965 in the United States, and we had universal suffrage much before that.
Yeah.
Uh, uh, but even besides that, at least to my mind, just because some ideas could perhaps be traced to the West, do not intrinsically make them Western to me. So, I mean, just because, say, there was an enlightenment in Europe before there was one in India or in South Asia, doesn't automatically make the ideas intrinsically Western, especially given the fact that the example of universal suffrage itself makes it clear that we adopted it even before, say, the United States. Perhaps, yeah, I mean, the superpower definitively in our times. I think, other than that, the other error, after listening to your response to the question, the other error which struck me is the fact that people who argue that the Constitution is colonial sort of expected our founding leaders to start off on a blank slate, to reject everything and then start off on a blank slate. I don't see how that could have happened either. An indigenous blank slate, apparently. Uh, how would you respond to that?
But only people who are blank slates can think that they can be original. People whose minds are that history did not happen before they thought about a problem, or history is irrelevant to the present. Past is irrelevant to present, not a prologue to the present and future, but it's irrelevant. So such anti-historical people with a retarded memory of the past, or the choice of not dealing with the past seriously, may say what pleases them, but it doesn't mean that that is the truth. The truth is that India, before the British came and before the invasions, for a history of 5,000 years. And I've been studying since I was a student. My first paper was in 1964. It was published in Bombay Road Reporter, and I can't trace it now. But that was an essay on relativism in ancient Indian legal thought, where I compared Sage Parasara of 5th century BC with a German thinker, Paul Gustav Radbruch, in 20th century. And I established that Sage Parasara, who spoke about Desh Kal Dharma, his problem was to identify the Dharma. And said Dharma is dependent on Desh, the territory, the culture, and Kala, that is Samaya, time. And Radbruch said in 20th century the same thing. And we plenty of students of jurisprudence who know Radbruch will never say Parasara. Right? So Radbruch said natural law with a changing content. Natural law with a changing content. Desha Kala Dharma. The same thing. Now, my idea was not to say that everything anticipated by India before anybody thought about it. That's a tall thing. My idea is to say our great ancestors thought about these problems. They asked what is Dharma, and they have number of answers to it. And what is Adharma? And there are different answers to it. And then came Buddhism and Jainism, as you know, all that, which discarded the idea of karma altogether. And Baba Saheb Ambedkar, who wrote a book, a small book, towards the end of his life, called Dhamma. Dhamma is the Buddhist for Dharma. And Baba Sahib said, I eliminate the idea of karma, I eliminate the idea of moksha. What is Dharma? The left of Dharma is just equality among people. Nobody is inferior, nobody is superior. Everybody is horizontally same. Everybody is equal. A modern word, as a Italian political scientist has invented, the Greek word, isocracy. Isocracy means complex equality. And I often say that our constitution works not democracy, but isocracy. That is, if you look at Article 14, equality before law and equal opportunity before law. Then Article 15 and 16, reservations for certain communities, certain classes, it doesn't say castes. There's a world of a difference between a class and a caste. So them looks similar. But Constitution speaks of other backward classes, not of castes. Classes may overlap with castes, but they are not the same as castes. So that's the difference. So in a sense, it's a politics of complex equality, competing equality, let us say. Equality of, Supreme Court of India said equality of merit and equality of outcomes. The two qualities immediately apparent. And Ambedkar himself said that in a famous speech on the adoption of the Constitution, 26 November 47, he said, and I quote him, on 26 January, we enter into a life of contradictions. There is political equality, one person, one vote. And you're right, we gave adult suffrage to everyone who was a citizen of India. So we enter into a life of contradiction. The political equality contrasted with social inequality and economic inequality. They contradict, Virodhabhas, contradiction. So we live under a life of contradiction even now, 75 years later. The contradiction persists. Whether we may measure today India's greatness by the number of billionaires it has produced since COVID, 200 of them. In the United States, billionaires will be the world's richest man or something like that. So, in a sense, the life of contradiction is very much with us in the Constitution. Unless you understand these contradictions, you can't understand the structure of rights, structure of justice. I say Constitution consists of four things, four ideas. Governance, development, rights, and justice. Now, if you look at the provisions and principles of Constitution, the last two, rights and justice, have a small part. Governance and development is a large part. That's a contradiction built into the text of the Constitution. The rights and justice part is part 3 and part 4, and it's so in the preamble. That's all. How many words of the Constitution does it comprise? And how many totality of words in the Constitution? And you will see the difference. It's a small part of the Constitution, rights provisions. And explicitly, justice is not talked about, except in part 4, the dietary principle of state policy. Anyway, I had a long digression on my part. I'm sorry for that, to at least cut me short when I ramble on.
No issues, sir. I think that's the best part about speaking as a scholar like you, the varied points of view that come into even a single answer. But like you've already mentioned the role of rights, and we also have questions based on power structures. But I would like to begin with that first. So your essays, your works, including towards the sociology of Indian law, have emphasized that the gap between formal legal ideals and social realities exists. Nearly 3 decades on since you published that, do you perceive this gap as having narrowed or widened, particularly given the recent debates around rights jurisprudence alongside persistent social and economic inequalities?
They contradict. Yes, they do. A constitution is a bundle of contradictions, and it emphasizes what I call, following a French philosopher, Marxist philosopher, Louis Althusser. Althusser said, talk about contradictory unity of the state. And the Indian Constitution does embody, crystallize the unity of the state which is contradictory. For example, take federalism. Strong center, but autonomous states. Not sovereign states, like American states, drawn a compact between different states and the federal government. So we adopted the idea of a strong center with autonomous states, federalism. It's often called quasi-federalism or semi-federalism, compared with the West, maybe. So yes, there are contradictions galore. And I think when Baba Sahib, coming back to your point about contradictions, we must surely ask for the Constitution, what kind of contradiction? Baba Sahib identified one major contradiction: social equality, inequality, and economic inequality versus political equality. Literature would call it material inequality. There are differences in life cycles and life chances of individuals. Those at the bottom of the heap get very little from the Constitution compared to those who are at the top and those who are at the middle. So constitutionally worst off people exist compared to constitutionally better off people, no smaller in number. My second article was published in the Journal of Indian Law Institute. The big review of 150 pages odd was of Granville Austin, who had just written a book on the Indian Constitution, the cornerstone of the nation. And I reviewed it for 150 pages in the Journal of Indian Law Institute, but I titled it, and I'm still searching for who wrote this quotation, but somebody wrote, little done, vast undone. I thought it was Alexander Pope, but it's not Pope. And I looked all my life for the student of literature before I joined law. And I just can't find the author. So it said, little done, vast undone. A study of Granville Austin's The Constitution of India. Now, one kind of contradiction is, how can you have revolution? Austin says it's a social and economic revolution. A charter of revolution, social revolution. T.T. Krishnamacharya, later on became Union Finance Minister in Nehru's cabinet. TTK was a member of Constituent Assembly, and he scoffed the idea of dialectic principles. And he said, if dialectic principles, that is part 4 of the Constitution, are a charter of revolution, then I must say, and these are his words, I quote, the revolution in a dustbin. Now, dustbin has revolutions, but we don't notice them unless we are scientists that study dust. or dustbins, things like that. We social scientists don't look at revolution in dustbin of history. A dustbin is a very interesting concept. TK did not elaborate it, but it is to me a very interesting concept. So that article I entitled as Little Done, Fast Undone. And if you look at 75 years of the Constitution, you can also say little done, vast undone. Now, undone has two meanings. Undone, that is, that which has been done is undone, or undone as addendum for the future. That's a different thing. Things we have to accomplish. There's a notion floated of Amrit Kal, when it's the centenary of the Constitution, 24 years hence. And we take steps to make Constitution more robust and strong. So people already started looking at what they should do 25 years hence with the Constitution. Now we had Constitution people saying, a number of people were saying, ours a colonial Constitution needs a change. They even cite a comparative constitutional law studies, COCOS, comparative constitutional law studies. COCOS says that the lifetime, average lifetime of a constitution all over the world is 19 years. And we've endured for 75 years, the time for change. There was a Constitutional Reform Commission set up by Mr. Bajpai in the terms of reference to change the Constitution. Chief Justice Beckett presided over it. Sodhi Soravji was a part of it. Very many constitutional experts. No academic is a constitutional expert basically, but those who are experts, practicing lawyers, judges, retired judges, they constitute the class of jurists, not people who teach them to be jurists. Yeah. They were there, and they, to one, they recommended that no changes are required in the Constitution. Nobody refers to why Vice-Chancellor committee said this. Everybody said Constitution is colonial. Now, what to do in this situation of poverty of thought? We as citizens, we are entitled to opinions and beliefs. Nobody can question your opinion or your belief. But when you're talking of something called the truth, objective history, then these things happen in India. And one of the charges against the Constitution was they thought change for the last 50, 60 years that time. And to change, there are two kinds of changes. Change for the sake of change. And change that matters. There are different kinds of change. Cosmetic changes, we have amendment. We've amended the Constitution more than 100 times. It's a flexible Constitution. And now Supreme Court said 50 years ago, basic structure and essential features of Constitution shall not be amended. They are unamendable amendments. And they have been struck down. A few have been struck down. So that's separate. So essentially, yes, Ambedkar had this notion of contradictions. But he did not have a well worked out notion of contradictions. And if we're going to study the contradictory unity of the state, then to study further. For example, contradiction can be normative, can be institutional, Supreme Court, Parliament, this is executive. They think differently, they're institutions under the Constitution. So normative, constitutional, institutional, there can be contradictions which are cultural and contradictions which are civilizational. What kind of contradictions the Constitution embodies is a worthwhile area of study. But I'll stop there. I want to hear you.
To pursue the theme of contradictions a bit further, one way, of course, as you pointed out, is via amendments. The Constitution is a flexible document which can be and has been amended several times. Another area which I recently got interested in was regarding the interpretation of Constitution, jurisprudence, and so on. And there I encountered two different paradigms or frameworks of interpreting constitutions. One of which I think was the originalist way of understanding constitutions or interpreting constitutions, and an evolutionary or a transformative view of interpreting or understanding constitutions. At least one challenge that comes to mind with a transformative view of understanding constitutions, as far as I understand it, is the fact that it can somehow be subordinated to the power of the state, or say what the political dispensation is championing, or through demagoguery, for instance. Now, it's true that we do have some safeguards for it, say regarding for instance, the basic structure of the Constitution, which ensures that beyond a certain point, you can't really bring in any changes, even if public mood happens to go against it, and it's expedient for the political party to champion such changes. But I was interested to know what your thoughts are on sort of these dichotomous views of understanding constitutions.
Well, yes, interpretation is ocean. In daily life, let's not forget the Constitution for a minute. People have forgotten it for a long time also, but I will not go into that. But forget the idea of Constitution and what it contains. We are interpretive animals. Human beings. I want a pen, please. Done. So I'm looking for it and I could write. So we interpret the word. We reinterpret the word. There's interpretation, reinterpretation. Reinterpretation, what has been interpreted. It goes on, it's ceaseless. The same process applies to Constitution. Constitution grow and develop by one amendment, by change, constitutional change. Thank you. And other is by amendment, formal amendment. The other is by interpretation, right? So constitutions do change. While the husk remains, the substance changes by interpretation. Interpretation of interpretation. So I have distinguished three phases. There were more. Interpretation, pre-interpretation, pre-interpreted text, interpretation, reinterpretation, and at the fourth one, post-interpretation. There are four phases. It's a constant activity. Now, there is a lot of cantankerous discussion on the so-called Lakshman Rekha, judicial overreach, and so on. And I'm studying the Ramayana now, at least stage in my looking at it. I'm working on the notion of Maryada. Maryada Purushottam Rama. Right? So I'm looking at this. What does Maryada mean philosophically? And how does it relate to Radharma? It's a separate idea. But interpretation can even reach to say you can't change the Constitution. That's what Keshwaranda Bharati did in 1973. In the case where 30 full court sat and said the argument before the court was a simple process of amendment can change the Indian preamble, constitutional preamble. It can, and Niran Day, the Attorney General, argued before the Supreme Court the following, that the Constitution declares in the preamble that we are a republican constitution. Parliament can change it to monarchy. The Constitutional preamble says fraternity. Parliament by law enacted may say hierarchy between men and women, between castes and non-castes, and so on. And so on. Every word of the Constitution can be changed, there are no limits. That was the argument of the then government of India. And Keshwaranda said, I'm under interpretation. That's sorry. There are limits on what we can do. That's interpretation. Who set the limit? We set the limit, but we don't set the limit. The Constitution sets the limit. The provisions and the principles of the Constitution. Provisions are explicit provisions, and principles are underlying the provision. Principles and provisions of the Constitution say it. We don't say it. We only expound it. So interpretation is a way of setting limits to power. That's why I'm interested in Maryada. The Dharma and Maryada. I'm working on it now at the moment. So Maryada is a kind of thing where limits to power. And the Constitution sets certain limits to all powers. The function of the Constitution, according to the Supreme Court, and according to general wisdom, reflection, is to set limits to all powers. It's to give powers. In fact, I've been emphasized very often, too often, that Constitution invests powers. The President, Parliament, and executive, various institutions. That's it. That should not be ignored. But also set limits. There is no unlimited power under the Constitution. That's the message of Constitution, Keshwaranda Bharati, based on the principles and provisions of the Constitution, including the power of judicial review, power by which courts may review the legislation. It is also limited. It's not absolute. So interpreting power itself says my power is limited. I'm not sovereign. People are sovereign. Nobody is sovereign. Every power is superior within its appointed jurisdiction. Every power is power under Constitution, not beyond it. That's what basic structure says. It uses two words, two phrases. Basic structure and essential features. You could have simply used the word basic structure. But it uses two phrases, basic structure and essential, which is essential feature about the basic structure. Now, I've read the 1,000-page, odd pages, Keshwaranda Bharati judgment 21 times, word by word. Now you might say, don't you have anything better in life to do? To read this judgment, maybe I'm a law teacher, so I have to read. So I prophesied, and I'm not in business of prophecy, that article as soon as I came to India from Australia. In 73, 74, I had an article, and judgment came to hand. And it began by saying that Keshwaranda Bharati, I was very new to India and in law. I said Keshwaranda Bharati judgment is not merely a judgment. It is the Constitution of India of the future. And my prophecy has turned out to be right. A minor prophet. Don't worry, I won't prophesy many things, but this much I do at the moment. So it is the parliament will recognize it, executive will recognize it, but judges recognize it. There is a small animal called Article 141 in the Constitution. And Article 141 said the law declared by the Supreme Court shall be binding on all courts of the territory of India. So interpretation stops at the Supreme Court. So there is a, people might say should not, but that's how life is. That's what they say. That interpretation is a judicial duty. Now there can be varieties of interpretation. For example, A.K. Gopalan, Article 21 was involved in 1950. And the constitution makers deliberately avoided. He praised due process. No life or liberty shall be taken away by due process of law, without due process of law. Instead of due process, they adopted the Japanese General MacArthur constitutional population. And what did the Japanese constitution say? Accepting procedure established by law. Not due process. In due process, judges come in, interpreting what is due process, what is undue process. Now, Supreme Court from A.K. Gopalan, right up to post-emergency Maneka Gandhi case, it interpreted procedure established by law. And they said Parliament may prescribe any procedure, as long as it is lawfully specified. It is okay. If you ask who sustained the constitutional validity of dragnet security law, starting with Preventive Detention Act to Prevention of Money Laundering Act now, who declared them constitutionally valid? The Supreme Court of India. All security legislation is held valid. Why? Because interpretation knows certain limits immanent to it, inside it. Which are the limits? The court has said, for example, limit number 1. There is no such thing as collective malafide. You can never show before the Supreme Court that Parliament acted malafide. Out of the question. The doctrine of malafides cannot apply to collective institutions. Second, the Supreme Court said there is a presumption of constitutionality. You quote Justice Vivian Bose in your website. And Vivian Bose said the Constitution is meant for common man. But it is not meant for the one man. If you take the first idea, that you cannot prove the malafides of parliament or legislature of state. Secondly, you cannot, there is a presumption of constitutionality of the law. And it is on the other side to show that the law is not constitutional. Why? Because Supreme Court recognizes that legislature it is which appreciates the needs of the people and sentiments of the people, when to make a law, when to amend the law, when to repeal a law, are legislative functions. And court does not legislate. It's the standard, it's the third proposition. The court does not legislate. It's just the validity of legislation. That's different. That's very different. But it does not judge the wisdom of the legislature. Because the legislature represents the people. And judicial review is in support of people wishes. So it is clear the Supreme Court has set limits to interpretation. Ignoramuses, present company excluded, would say that the judiciary has control, exercise of power. That's wrong. The judicial overreach, so the Lakshman Rekha is violated. No. The court does its constitutional duty. Recently, very recently, on May 5, a short judgment by Chief Justice Khanna on the contempt of court petition against the remarks passed by Mr. Dubey, Member of Parliament, Michigan Dubey. And court said, of course, the element of hate speech, paragraph 6 of that short order. If there is hate speech, the law must deal with it sternly, but contempt of the court, our shoulders are broad enough, we ignore it. But it says judicial review is a constitutional duty. And in fact, there's a small article, Article 32 in the Constitution, a part of fundamental rights, which says there's a right to constitutional remedies. And citizens can approach the Supreme Court if their fundamental rights are violated. They may not agree with what the court says. That's obvious. But they must accept what the court says, because they know higher court than Supreme Court of India. It may be fallible, but it is final. Supreme Court is final. There is no court beyond it. It may go wrong, according to you. It may revise its view later, saying it has gone wrong. Like in the infamous habeas corpus case, Justice Bhagwati and Justice Chandrachud sustained the Maintenance of Internal Security Act in 1975, to the point of saying that I have no right to habeas corpus, even if the case is one of mistaken identity. During an emergency, they can do anything they like. That's what the judgment said. And a long book called Indian Supreme Court and Politics, which is readable by anybody. You don't have to be a lawyer to read in the 80s, which translates judges' judgment into ordinary language. And recently I was at an occasion where a judge of the Supreme Court was presiding, Justice Oak, and he said he never found a person in this wide world with the temerity to translate Justice Krishna Iyer into common language. And that was a passage of mine from the future, from the Indian Supreme Court and Politics. And amazingly, I translated even Krishna Iyer into simple common man's language. I must have been very young with that. But I did that. So it's important to read judgments of the Supreme Court as speaking to the people of India, and somebody has to do the act of translation. Without translation, you can't reach everybody, people of India. Now, Supreme Court itself accepted the idea. All these judgments are one-page summary. I suggested lifelong suggestion to Supreme Court was that should issue a one-page summary of each judgment. It should be translated in all the languages that are recognized by the Constitution. 21, I think. And they should be equally binding as the judgment. That's judicial accountability. At long last, they have accepted the suggestion. I made it some 25 years ago. I made it insistently. And they know reference to me, but it doesn't matter. It doesn't matter. The job is done. The point is, my writings, it doesn't matter. I'm a well-wisher of the court. I suggested it, and and did in Mathura open letter to Chief Justice of India with my colleagues. And eventually the law was changed. We fought for reform and rape law. It took 5 years, but the Parliament changed it and finished the rape bar. They could not inquire into the past sexual history of the rape woman. Because various types of rape, and we identified power rape, economic rape, dominant rape. The penal code has been changed because of us, 4 of us, law teachers. So that's a different matter. So one can essentially, Parliament is supreme, and the court has recognized its supremacy under the Constitution. It cannot act unconstitutional. So it's Supreme Court supreme. There are limits to interpretation. It can't second guess the wisdom of Parliament. No. Policy of Parliament. No. You have to show that a particular right constellation is violated. They do not issue stay laws on legislation. They do not mandamus the President of India ever. Although I'd filed a petition of contempt of the court by the President of India in Manmohan Singh's time, as a citizen, because Prime Minister Manmohan Singh was the chairperson of the Narmada Dam Committee, Grievance Committee. And the court had directed the Grievance Committee should report, and he had not reported. They said, we can't issue a mandamus to the Prime Minister. In open court. Immediately they would issue a mandamus to the President of India. Then there is some committee between institutions of constitution. But short of that, they would do anything. So there are limits to interpretation. And interpretation is changeable. The literal interpretation, like you said, originalist interpretation. The constitution makers, for example, had said there is no right to speedy trial, and they gave the reasons. And they did not include it in Fundamental Rights Chapter Part 3. Some 50 years later, the court said, no matter whether the Constitution has adopted this provision or not, we say that Article 21, right to life and liberty, includes the right to speedy trial. It was not put and deliberated upon by Constitutional Assembly. It's now a fundamental right under 21. And petitions have been filed. Lo and behold, when undue time is taken, what is undue is a matter of interpretation. There are people who are suffering for a generation before the case is taken away. And I said to my friends overseas who work on intergenerational justice, I said, come to Delhi. If you want to understand books on what intergenerational justice means, I said, why writing books? To come and watch the Supreme Court. A case filed in one generation is decided in the second or third generation. We actually do it. No difficulty about it. Our people are content, our executive is content, our judiciary is content. Supreme Court recently said to one of my friends, pension dispute. I won't mention name, the professor, and very bright professor. And she read this problem. In 8 years, the judge said, ma'am, 8 years? And you say delay? Wait, be patient. Your turn will come. So this is very interesting. Very interesting in the sense that delay is measurement of time from the start of what is delay. I did a book called A Crisis for Indian Legal System, in which I explain a chapter, Courts and Crisis. in which I said, what is delay? What constitutes a delay? And it's a very complex area because delay is extraordinary time consumption. What is extraordinary time consumption? So delay to filing. And my solution was that there are different types of causes of delay. One is the court-induced delays, one is the party-induced delays. Sometimes parties don't put this decision, they want adjournment. They just file a case, but they don't want it to come to a conclusion. Ordinarily, we think people go to court to get outcome, but very often courts are used for not having an outcome. To litigate in tenancy cases, very often you will find the tenant is interested in delaying decision and law because he wants to stay in the house. The landlord wants eviction. There are many divorce, there are many other cases. So delay is go by offense. And I measured that empirically. And I found that India, there rarely prosecution for perjury, so there's no delay. There's no prosecution. They all amount lying in the court, before the court. But the murder cases appeal to the Supreme Court or the High Court. It takes 2 years more. And Supreme Court says 2 years or more is delay. Supreme Court must speak. There are cases of theft, cases now of cyber theft. What is delay is measured by each offense. And I measured it that time in my book. And I found that different considerations apply different matters. I won't go into that. But delay is not a simple problem. That's the short point I wanted to make.
Thank you for that answer, sir. And I think there's a lot to unpack there, but the main thing that I do want to speak to you about is you mentioned Justice Vivian Bose and his quote that the Constitution exists for the common man, the poor, and the humble, for those who have businesses at stake, the butcher, the baker, and the candlestick maker. This quote has resonated with me since the marriage equality case when senior advocate Raja Ramachandran opened his oral arguments for the petitioners with the same, and we spoke to him back in 2023, and senior advocate Sanjay Hegde as well. And that case, we later also spoke to Justice Dr. S. Muralidhar and advocate Gautam Bhatia on the same matter. And in your answer, you mentioned that there's a limitation to what the court can do and what the judges of the court cannot do through the power they wield. Now, essentially, the doctrine of separation of powers came in the limelight in that case, where many criticized the judgment, saying that instead of seeing it as an anti-discrimination case against queer people, it turned into a case where everyone thought that special provisions must be given to queer people, which of course it wasn't. The case wasn't like that, but the judgment said it was. So how do you interpret this situation where the judges have to navigate a situation where there's a vacuum of rights and the parliament is not willing to act on that vacuum? Would this come under the umbrella of judicial activism, some Lakshman Rekha they should not cross, or in certain situations the court should act as a legislature?
Well, I think a court has acted as, thank you, a court has acted as legislator in very few cases. And Justice Verma and Justice the woman judge, Justice, my friend, I forget his name at the moment. And they both passed in Vishaka, in a case called Vishaka. They passed a law against sexual harassment. And it was 50th anniversary gift. And they said our law, the law declared by the Supreme Court, shall be binding till Parliament makes a law on sexual harassment, which it did after 13 years. The 13 years were ruled by the Supreme Court law. Now, such direct exercise legislation are rare, few and far between. Most of the time, the work is done on the guise of interpretation. They're holding a law valid or limited reading of the limited part being held valid, other parts kept in abeyance. So it is there. But nobody looks at the executive and legislature. Only look at the courts, which I think wrong. For example, there is a power in Parliament to delegate legislation, rule-making authority to the executive. It's a function of Parliament to make rules and law, but delegates this function. Now, such delegation was understandable when India became independent. Now, we still have delegated legislation. A large number of regulations are made by the executive and upheld by the courts, including legislation that may create crimes by rules, that can create property by rules, or the state property or the private property and so on. So delegate legislation, nobody studies in India, except the bare bones, the principle that it's okay to pass it on to executive. Bulk of Indians are governed by executive rule making, not by parliamentary legislation. There is a rise and rise, as one article, one blog, said the rise and rise of delegated legislation. There is no rise and fall, formerly rise and decline, but rise and rise. And that is available in the blog of Merchant Shop and Company. The article is called The Rise and Rise of Delegated Legislation. And the blog says, written by two lawyers, veteran lawyers. And it says, things have come to such a pass that even corporations do not know that they are bound by a particular regulation. Let alone individuals. Corporations are big things, they've got an army of research assistants, they can look at everything concerning them. And they're saying the same genie that is run out of the bottle. I mean, in a sense, everything is, and they say about SEBI. SEBI makes rules. SEBI is the Security and Exchange Control Board of India. SEBI makes the rules every second day. It legislates every second day. It is more than Parliament of India. It has approved. They have the figures for that. 150 or more legislation, executive legislation. So that corporate capitalist class protests against this law. Now, if you look at legal literacy, the idea that everybody should know the law, apply to delegated legislation. It is very hard to find the copy of the Gazette that created the offense, despite computers, despite research that is generating. There are so many rules and regulations passed by the executive, which people do not even know about. the staggering rate of legal illiteracy is very high. There's something called the India Code. It's supposed to represent all the laws of India. But even that is not complete, and it leaves out many executive legislatures. My friend, Dr. Vazbab, a lamented friend in Pune, Gokhale Institute, wrote a series of books on legislations, including delegated legislation, 5 volumes, I think, on land reforms in India. Kindly look at that. It's voluntary. He worked for years on this, D.C. Vazbab. 5 volumes. And he still could not completely state all the law, including gazette notification. So delegated legislation is uncontrolled phenomenon in India. And bulk of the law that governs Indians is in delegated legislation. As far as the other aspect you mentioned, namely separation of powers, our court, Supreme Court, has ruled in 1955 in a case called Ramjaya Kapoor concerning school textbooks that we in India do not know, and mark the words, we in India do not know this, we don't have a doctrine of strict separation of powers. Strict separation of powers. The Supreme Court has enunciated this again in 1973 in case of Nabati and said the same thing, that our Constitution does not contemplate a strict. Now, what in the name of everything that is dear to you, may I ask you, what is the strict separation of power? Either a thing is separation of powers or it is not. What is this strict? Every word in law matters. Of course, my children don't follow what I say, but eventually would. Some of them become judges, some become Chief Justice of India, and so on. But nevertheless, they say they strict separation of powers. What is strict? Just think about it. I think the idea of delegated legislation is accepted by a long chalk by saying there is no strict separation of power. So the executive can legislate. It's not a function of the executive legislate under separation of power. The mega separation of powers is between legislature, executive, and judiciary. I call it mega. The micro mini is separation of powers, panchayat and all that. I won't go there. So, do we have some judges like my friend at the Supreme Court from West Bengal? She was a strong critic of collegium. And she said that separation of powers is violated. Now, if we don't know the meaning of the word separation of powers, how can we say separation of powers is violated? Either the thing exists or it does not exist. There's no third way out of it. If you make way for legislation being done by executive, when you say we don't have a strict separation of power, or by the judiciary, we don't have a strict section of power, Visakha. Then what we have is delicious confusion or dangerous confusion. It depends on the context in which you want to look at it. So I think we have to be careful. I just did a report for the chairperson of Rajya Sabha. I know what you do with it on this whole business of separation of powers. And I think the dignity of legislation is maintained by the idea of separation of powers. But when the separation of powers is hermetically sealed, as it were, between executive, legislature, and judiciary, is an open question. Because we don't have a strict separation of powers according to the judgments of the court. So you can make, but the number one problem in the legal system is accountability to the poor. You're quite right. Accountability to in my words, to constitutional have-nots. Not impunity, accountability. And I used to tell my friend Justice Krishna Iyer, when the earthquake of a judge, he shook to the roots many ideas he had. Kindly read Justice Krishna Iyer. But Justice Krishna Iyer said, he quoted Mohandas Gandhi, and he said, I want to wipe from judgment every tear from every eye. That is the idea of power, Mahatma Gandhi. To wipe every tear from every eye. And he used this phrase several times in judgment. Then I went to him and said, Krishna, I used to privilege to call him by his first name. I said, next time you say wipe every tear from every eye, I'm going to write an article. He said, when, what are you doing? Not writing. And the title would be Trachoma. And one of the main causes of trachoma is tattered handkerchief, or glaucoma. So if you wipe every judicial handkerchief which is tattered, and you try to wipe every tear, you spread the disease whereby persons lose their sight. I must say that Krishna played very cautious there. He said, he didn't say if you don't write the article, but freedom of speech issue. But he said, yes, I take note of what you say, and he did. It's not right to do the tattered judicial handkerchief. You wipe every tear from every eye. You can't do that. There are people left behind, severely left behind, the right to constitutional remedies in Article 32 of the Constitution. It's a fundamental right. Everybody has the right to approach the Supreme Court. Who can approach the Supreme Court? Who can afford the fees of the lawyers? How much they charge? I won't mention names, but Delhi University, a leading lawyer, whom we consulted on a minor issue, sent the university a bill for 75,000 rupees for consultation, for an opinion. And here I was, as Vice-Chancellor of Delhi University, battling on all fronts because my grants were cut by Principal Manmohan Singh, Prime Minister, and Arjun Singh, and running from pillar to post for money. Because every resource I raised, UGC claimed that it's own under rules. So those were the times of liberalization, early liberalization. Anyway, so I think it is not possible that the Constitution, Part 4, clearly says that state shall do this and do that and do that for the weaker sections of the society. My students and I had a course called legislative drafting. How do you draft the law? And once I said we should have a constitutional amendment. That's what about constitutional amendment? After constitutional amendment, because I was a part of the weaker sections of society in 1950. I was still a part in 1960, 70, 80, 90, 20, 25. So ultimately I suggested a formula. I said the Constitution directive principle should not use the word weaker sections of society, but should instead say progressively weakened sections of society. The state has an obligation to progressively weaken sections of Indian society. We sent the amendment draft proposal to Santi Bhushanji, who was the law minister. Then we did not even get an acknowledgement. Let's be ready for that. But that's a different matter. We didn't wait for acknowledgement. We made our suggestion. So I think there is something. You can't be a weaker section of society for all time to come. It has to be progressively weakened section. That means you've taken care of some weaker section earlier. But I can't be a weaker section all my life. That's what Part 4 means. So there is a problem here of rate of change, the pace of change, the direction of change, how far the change is constitutional, and how far the change is undemocratic and anti-constitutional. Who is to decide that? And these are important questions. Sorry.
Thank you so much for that answer. So we just want to ask, would you have time for one final question?
Yeah.
Okay, thank you so much. So, based off that question, you have previously written about the emergence of post-constitutional regimes and the interpretation of the constitution beyond just a constitutional document. Now, we have engaged many scholars in the past, and one of the works we really do enjoy reading is by scholar Rohit Day. And Rohit Day's notion of subaltern constitutionalism foregrounds the experiences of marginalized communities as a way to interpret the constitution. Now, in your opinion, in what ways does this perspective resonate with the emphasis on the notions of law and inclusive justice? And do you think subaltern constitutionalism extends your vision, or does it suggest new directions?
Thank you indeed, Rohit. Yes, Rohit's book on the Supreme Court and Article 32 is a masterpiece, historical masterpiece. It takes four cases, four individuals. I read it as a study in socialization of Article 32. That Article 32, right to constitutional remedies, belongs to us all. But Rohit has gone further with Ornith Sani, and his second book is coming out on this, apart from the idea of people's court. And that's an eye-opener, because it says that contrary to all the stories about constitution making, that Granville Austin says constitution was made by a constitutional oligarchy. Or somebody said colonial constitution. So certain people mattered. Ornith Sani and Rohit Day have now a book coming by Oxford, in which they found number of petitions addressed to Constituent Assembly itself by citizens and by citizens group. And many of them were acknowledged by Secretariat of Constituent Assembly. And they found a treasure of documents. And this is the second phase of their writing on People's Court. So in a sense, we have now hard historical evidence that the Constitution was not only made by an oligarchy, a drafting committee, which played a leading role, but throughout the country, the formerly oppressed people, the subjects of the Queen or King of Britain, had a stake in the making of the Constitution, and they made suggestions on how the Constitution should be made throughout the length and breadth of India. And these letters, petitions, were done by collectivities, labor unions, or some associations. or by individuals were recognized and taken into account in the making of the Constitution. This is coming out next year or something. I've given a blurb, so I know there's the book here somewhere, the manuscript. But I think it's a whale of a book. It explores several myths about constitution making. And it gives you solid facts as to how the people of India, to whom the Constitution is dedicated, actually before independence, they made suggestions to the Constituent Assembly on how the Constitution should be framed. And this is most extraordinary. So I'm glad that you mentioned Rohit and his work. This is Rohit and Ornit Sahni, who worked on petition. And they actually participated in the constitution making process. That's the claim. And the claim is, I think, more than fully substantiated by the authors. So do have a look at the book when it comes out, I think later this year. So in a sense, these are materials which also explode the propaganda or myth that our constitution is colonial. Please, may I ask for return fee, as you were for speaking ad nauseum. Return fees, please, if you are interested in the constitution or saving it, do not regard it as a colonial document. Pure propaganda, utter nonsense and logical sense. It's not based on any analysis or frame of reference. And it's vacuous. It doesn't say anything to anyone unless people want to make use of it as a rhetorical flourish. Damn, it doesn't. People can do that. I don't think the achievement, extraordinary achievement of the Constitution in a poor society should be brushed aside cavalierly in this fashion by calling it colonial or feudal. No doubt the Constitution has several problems, no doubt in whether in Justice Vivian Bose or in terms of Krishna Iyer or in terms of Chandrachud and beyond. Judges have been constantly saying that we must try to make justice available and to doorstep of people. No doubt there have been Ramanayas and revival of Nyaya Panchayati, revival of Panchayati Raj that we must also study by a constitutional amendment. But I think, and no doubt there has been a combined effort by legislature, judiciary and executive to make constitution more relevant to the life of the people. But I do think, however, that time has come to make judiciary as populous numerically as the legislature and the executive. How many IAS officers you have got compared to judges in the Supreme Court? Is it justifiable to have only 33 Supreme Court justices and about 500 odd High Court justices in a country, as somebody says, of 1.5 billion people whom he or she represents? Long time back, Justice D. Desai of the Supreme Court, and I helped him, and there was the Law Commission. He produced a small report of the Law Commission, which said judicial, and I'm sorry for men because manpower is commonly used, but not person power. But manpower planning, the term had to be used. in which we said, arising from my experience in Bhopal, tragedy, catastrophe on the ground, and many others. My experience as activist, I poured into it. And that report said, very small report, that India should at least have 50 judges per 1 lakh of population. So there is no, the burden is burden of co-governing India. The judiciary governs India also, is unevenly spread throughout executive, legislature, and judiciary. In French Parliament, even other institutions, French Parliament is 1,000 deputies, legislators. How many we are? Compared to the size of the country and the number of people, 535 at the most. Lok Sabha and Rajya Sabha combined, and 8 legislators. So we must ask it. I've been saying it since 1973 when I came here to teach at Delhi University, that we must have an understanding of the demography of law, social demography of law. How many judges per millions of people? How many police thanas per millions of people? We make laws creating new offenses. How many investigators, how many jails? We keep on making laws. In fact, I one time said in my crisis of Indian legal system that if the measure was not GDP, gross development product, but GLP, India would be the most developed country in the world. What is GLP? I said GLP stands for gross legislative product. Our GLP is 100,000 times larger than the GDP. No nation can beat us in terms of numbers of laws, and delegated legislation included. We have a large number of laws, but institutional planning we utterly lack. And let us hope that in the 25 years or 24 that remain for the constitutional centenary, I will not be there for sure, but let us hope that in the Amrit Kal, as it is called, we will have the bench strength of judiciary throughout the country, police, of prosecutors, of district courts, at least some less arbitrary goalposts will be set. A country of this size cannot be governed by a small elite, no matter how hard they try. And justice, dispensation of justice, is a task not only of governance, but also of development. The Indian Constitution contains, as I said, 4 ideas: governance, development, rights, and justice. And I don't think our delivery institutions are designed, manpower planning are designed to reach that people of India, the common man, about which Vivian Bose talked about, or which you talked about, Krishna, about whom I talked about. Judges are acutely conscious that justice does not reach people. And just to be made, people's faith in judicial review depends on delivery of justice and in time. And that can only be done by having more people on the job.
Thank you so much, Professor Baxi. We'll indeed do our best to carry the torch forward. One thing that I didn't mention in my first question, but I really loved your takedown of the accusation that the Constitution is colonial, is the sheer fact that the scholars who still try to resurrect this dead horse, despite so much time having passed since it's been dismissed and debunked, is the extent to which they go. One of them even blamed the spraying of disinfectants on migrant workers, somehow to the fact that this constitution apparently has a colonial origin. I mean, that's really the ludicrous extent to which they go in the accusation. So I really love the way you took down this charge, and really hope that the vision that the constitution embodies is actually implemented via an improvement in the infrastructure over time. And we'll certainly do whatever is in our capacity to realize this vision. Thank you so much for being so generous with your time. I think 100 minutes.
Oh my goodness. We must go. We must go.
Our conversation lasted 100 minutes. We hope it didn't tire you out or bore you with our questions. And we'd love to stay in touch, surely, sir. Thank you so much for your time.
Thank you indeed. Thank you. So long. All the best. All the best.